Welcome back to Social Media Law and Risk Management. And this week we're looking at Module 3, Lecture 2, and we're examining privacy and confidentiality in social media. Now, you really need to read 2 chapters of the textbook for this, chapters 5 and chapter 6, which covers those topics. We also, this week, will be looking at your learning problem as usual, which covers this area. We'll be looking at the origins of privacy internationally. We'll be considering whether privacy and confidentiality are a celebrity issue or it's something that really concerns all of us. The issue of data protection, which has certainly had a lot more currency in recent times with anti-terror laws. We'll be having an introduction to cyberstalking and bullying, although we look much more closely at that in a future week. We'll be considering the law of confidentiality internationally and the nature of shielding sources with shield laws and protection of whistleblowers. And finally, we'll pose a few discussion questions as usual. Well, your learning problem this week is to do with a drug company PR person. Now, you had a foreshadowing of this last week, but it starts to take on a lot more meaning as we look at privacy and confidentiality. You're the communications manager of a major pharmaceutical, and the leading cholesterol product that you're producing, cont'd, the sales have plummeted because the patents run out and there's generic brands on the market. And your new company president has a strong sales background and really wants to ramp up the sales. So he returns from a long lunch with a colleague and shoots out this email. Top secret. Desperate times demand desperate measures. We've negotiated an arrangement with the cheapest chemical corp to obtain all customer details from their prescription database. Now, I won't read all of this simply because it'll take up the whole lecture time. But he goes on to look at the, to ask staff to destroy copies of the research that shows there are some problems with the product. And your concern that about the manager's, breaching of people's privacy, I guess. There's a whole range of things to do with these weeks that you could be concerned about. But you also have a friend who is a investigative reporter and a health correspondent. So you're planning on getting together via social media and tipping this friend off to this story. So there are a couple of strategies that might be involved there, and all of this is excellent background to our discussion of privacy and confidentiality, because there are several touchstones during the lecture which will be relevant to that learning problem. The usual questions apply to the learning problem, the ones you see on the screen now to do with the legal issues, the key elements of these areas of the law, liability for various people, cases that you might have found that have some relevance here, which courts might have jurisdiction, how might it differ between different countries, and how stakeholder theory might help us in our deliberations. Most importantly, we start to talk about the risks faced by your organisation and you in the process, what action you might take over it, and how social media policies might inform this matter, how they might be best worded to avoid these situations. So let's move into the origins of privacy and its variations globally. And while people may have had some feeling about privacy and their right to privacy a long time ago, it was really only over the last 150 years or so that we've seen privacy develop as a legal right in the main parts of the world, at least the main parts of the Western world. So while there might have been cultural notions of privacy, it hasn't really reached Western law until that period. And the textbook talks about the development in France with a celebrity author, Alexandre Dumas, in 1867, and how the courts found that the privacy was more of an issue than copyright when a photographer had taken some fairly saucy photographs of him with his girlfriend in various states of dress for a photo shoot, and then the photographer had gone off and tried to sell these to others. Dumas was looking, or his lawyers were looking at a suit in copyright for breach of copyright, but he found satisfaction in the courts with contesting it on the grounds of a breach to his right to privacy. Now, while I say they were saucy photographs, the textbook explains that by today's standards they were far from saucy. So it's not like they were in great state of undress. It was more that she was wearing slightly lesser garments than she would normally wear in that day and age. But nevertheless, embarrassing in that cultural situation for others to view them. It was another 25 years or so before privacy was developed as a notion or as a potential legal right in the United States. Across the Atlantic, two great jurists, Warren and Brandeis, actually wrote an article for the Harvard Law Review called A Right to Privacy. And this was after one of their private parties had been basically discovered by the media, and the whole guest list had been published in the local newspaper. So this caused shock and horror in the elite legal circles that the media should disclose the private details of the attendance list at a private function, and that was basically the beginning of the right to privacy. So what we see here is that privacy as a legal right, while it might not only protect the rich and famous, was certainly established because of situations involving the rich and famous, celebrity suits. These days, the legal right to privacy is recognised in most international human rights treaties. It's also recognised in some constitutions, and it's recognised by the higher courts in most Western democracies. Australia is an exception there, and we'll talk about that in a moment. Related here also are various big cases that have happened in the UK. And one of these was to do with a super injunction and a footballer called Ryan Giggs. And the idea of an injunction, a court injunction or a suppression order, is where a court orders the media not to publish certain parts of a court case or identify people involved. A super injunction is where the court even goes to the extent of banning the publication of the injunction itself. So they don't want the news to get out that even an injunction, a suppression, has been issued. And in Giggs's case, the word got out very quickly on social media that there was such an injunction, and the courts were left in a bind. Here they had issued a very important order not to publicise something when thousands of Twitter users were breaking the secret. It became quite a farce, actually, when a Scottish newspaper published Giggs's photo with a very, very small band across his eyes so that anyone could still recognise who he was, and breached the suppression order, but they were out of the reach of the English jurisdiction up in Scotland. We've also had a whole range of cases to do with the unethical behaviour of the News of the World newspaper and other British tabloids when they hired private investigators to listen in and record the conversations on people's phones, to bug various things, and to trade this information in quite corrupt acts with the police. So these venture into the area of privacy and just explain why privacy is such a big issue in the modern era, particularly in the context of sports stars like Giggs, authors, celebrity authors like Dumas, and wealthy people like the lawyers Warren and Brandeis. In Australia as yet, as I speak today, in 2015, there is no legal right to privacy decided by our High Court. Our High Court has left the door open, and the textbook talks about a case called the Lenar Game Meats case, which was where some trespassers had left a hidden camera in an abattoir in Tasmania to record the practices of possum slaughter in that abattoir. They had then given the footage anonymously to the ABC's 7:30 report, who proposed to broadcast this as part of an expose on these possum slaughtering practices. Well, Lennar Game Meats, the abattoir, took the ABC all the way to the High Court to try to stop that publication on the grounds that it had breached their right to privacy. But the High Court decided there was not yet a right to privacy in Australia, and that the ABC was able to use the fruits of a trespass like that in the public interest. But they did leave the door open for the potential development of a right to privacy in the future. A case that's mentioned where we did have a right to privacy decided was in a lower court though. It was in the County Court in Victoria, in the Jane Doe case against the ABC, where ABC reporters had inadvertently named a rape victim, and they had been prosecuted for the breach of that legislation that bans the naming of a rape victim, but they had in turn been sued for breach of privacy or invasion of privacy by the rape victim in the civil courts over that breach. And they won, Jane Doe, the litigant, won that case against the ABC, and they chose not to appeal that any further. One guesses because they did not want a right to privacy developed in a higher court when it was such a straightforward case. Well, is privacy a celebrity issue or a broader human right? And, well, it is protected by various human rights instruments. The Universal Declaration of Human Rights protects privacy, as do most of the other major regional human rights treaties. But it does often come second to other rights, such as free expression or national security laws. And the UK law particularly has been dominated by celebrity suits, we call them, by the likes of the actors, Catherine Zeta-Jones and Michael Douglas, the supermodel Naomi Campbell, and Formula One's Max Mosley. The area linked to privacy rights is data protection, and we do see a lot of conversation, discussion about this in the public domain at the moment, particularly with governments wanting more rights to access citizens' data for the sake of anti-terror, for national security. Most Western democracies do have fairly strict data protection laws applying to private corporations. In Australia, under the Privacy Act, which applies to both private corporations and government. And there's special concern for people who are using social media, perhaps by spamming, perhaps by phishing for information about customers to add to their databases, which they might in turn sell off to other organisations. So there are very restricted rules for that kind of practice. We've also had over the years all sorts of major security breaches despite data protection laws, and one of the most famous internationally was Sony's PlayStation credit card data leak in 2011. In Australia, in recent times, we've even found the details, including the passports numbers and all sorts of private details on the G20 leaders released inadvertently by the Immigration Department in Australia after the G20 conference there in 2014. We do talk in a later week about cyberstalking and cyberbullying, and so I'm not going to dwell on it here. I have blogged on this issue, so you could look at that blog on my journlaw.com blog. The Australian government, through its CyberSmart scheme, recommends a talk, report, support approach. And they advise victims that they should talk about a threat if someone has made that online, and they should basically discuss it for counselling reasons with someone that they trust, avoid retaliating or responding, block the bully if they can, and change their privacy settings, and report the abuse to the service itself at least, if not the police, and then collect any evidence in case there is an ensuing police case. cyberstalkers and bulliers could breach many, many laws, which we look at in a future chapter. But these include blackmail, the misuse of a carriage service, a telecommunications service, and stalking and harassment laws. The law of confidentiality is a bit different from the law of privacy, although in some places it's been converged with privacy law. In the UK and Australia, the breach of confidence law has a 3-point test associated with it. Firstly, information needs to have a quality of confidence about it. The circumstances in which the confidentiality is broken, has been given, gives rise to an obligation of confidence. And thirdly, there needs to be some threat or actual negative use of the information that breaches that confidence. And confidential information can be all sorts of things, including documents, of course, ideas, verbal secrets, and artworks or electronic works and objects. The US elements of the action include public disclosure of the secret, of a private fact, which would be offensive to a reasonable person and not newsworthy or of public concern. So there's a strong public interest defence built into the US definition of breach of confidence. The other big issue in this area is actually shielding sources and protecting whistleblowers, both by government and those who are dealing with journalists. Because there are all sorts of aspects to secrets as such. Concealing them, which we're meant to do if we're protecting a source. Finding them, which we need to do if we are journalists or other types of researchers or investigators. And actually revealing or blabbing them, where we can find ourselves in breach of these breach of confidence laws. As far as sources and secrets go, governments often have legislation giving whistleblowers immunity, but not so much if they go via the media. So not all countries have protections of sources if they decide to disclose their secret via the media. Journalists come up against the area of disobedience contempt by refusing a court order to answer their question if they try to stick by the ethical obligation to a source. Some jurisdictions have shield laws actually protecting journalists explicitly. In Australia, we have some of these laws, as they do in many states of the United States. The UK also has a shield law under its Contempt of Court Act. The trouble is, with Web 2 being multi-jurisdictional, your sources might be in one place, you might be in another, and this protection may be very hard to identify and defend. Confidentiality is also an ethical issue, of course, and this is where we find a journalist's ethics colliding with the legal obligations. There are a number of strategies that journalists and sources can use, which are stated in the textbook, but clearly in this modern era, many top journalists are suggesting to go back to quite primitive methods of contact, meeting people in restaurants or in car parks, not having phones turned on because of geolocational technologies, trying to avoid CCTV cameras, and not communicating by phone or email unless it's in an encrypted situation. There's also the area of freedom of information applications, which can be used to protect a source. So, for example, if a source manages to tell you where you will find information in a letter to a government department or something like that, you can actually specifically request that document, which avoids the obligation of confidence to the source. This topic area has a range of discussion questions attached to it, which are sitting there on the slide on discussion questions for you. I'd encourage you to go to the discussion board to discuss those questions. And next week we'll be looking at a range of things. Here we've looked at these two big areas of privacy and confidentiality. Next week we're going to put this together in our workshop, so there won't be a formal lecture next week, but we'll skip through to the next module before you see me again for our next lecture. So please get out there on the discussion board and discuss your discussion questions and your learning problem before we have our workshop next week. We'll see you then.